A 3-judge panel is assigned for a constitutional challenge of divorce. 50% divorce rate. Come on, folks. And there's not a problem. Children are not with their natural parents. A 3-judge panel has been assigned in a Pennsylvania Superior Court to decide an appeal challenging the constitutionality of Pennsylvania's unilateral no-fault divorce statute. Whoops. I know we made a commitment here, but you know what, honey? I unilaterally have decided I'm not going to keep it. I've changed my mind. Okay? What are you going to say? It's a no-fault divorce, right? The appeal is by Ryan Pankoe, who was left by his wife, who filed a plea for unilateral no-fault divorce, which means if one person wants it, you got to have it. Now think about that, because we're going to get into what that means. He's the chief of an ambulance company, an Eagle Scout, and a Scout leader, and a Christian, by the way. Ryan and his wife have 2 sons, and Ryan says he's defending his fundamental rights and hopes to also help others. When a state law impairs upon fundamental rights and an aggrieved party makes a complaint that the statute is unconstitutional, the burden of proof is on the state to prove why the statute serves the public interest, and the public interest is all the public. Now think about this, unilateral and all the public. Do you see a problem brewing yet? Maybe not? Okay. When a statute is unconstitutional, the court has no subject matter jurisdiction and the case must be dismissed. In other words, he's saying that unilateral divorce is unconstitutional. Marriage, children, and property are fundamental rights. In other words, this gentleman has a right to be married. Think about the logic here. She's saying, I'm done with this. I'm not going to keep my commitment. And he's saying, well, I want to be married, and I have a right to be married.
Interesting.
In his appeal, Ryan argues in favor of 3 questions. Whether the law is hostile towards religious views that oppose particular state-sponsored and established ideological authority, orthodoxily, I should have said authority because I can pronounce that, in violation of the established clause. His preferred answer is yes. Number 2, again, law eliminates the right of defense against the specified statutory cause of action for divorce in violation of due process. Eliminates the right of defense. If it's unilateral, in other words, if the wife or the spouse can walk away from it and say, okay, I'm done, and you have no remedy, then what use is the law? It has to offer remedy. If okay, I'm going to go ahead and steal something from you, and the law says that you have no remedy, then you can't come after me and say, well, this guy belongs in jail, and I want my money back. You have no remedy. I unilaterally decided that I was going to steal from you, and the law doesn't allow for you any remedy, any solution to that. He's saying that when he walks into the judge, that they're not really being a judge, because there's nothing to judge here. They're just ministering to the no-fault divorce law. There's no remedy for this guy, but they're going before a judge anyway. What's the judge supposed to do? Determine, right? Well, it's already been determined, so why do you have a judge? If you don't have a remedy and the judge isn't judging, what are you doing in court?
Good question.
This is incredible. This is incredible the way that this is being approached. In Ryan's summary, he shows that the divorce statute is based on the plaintiff's viewpoint, not based on the behavior of the defendant. In other words, he was doing everything was right, and maybe she was doing everything was right, except I'm done. Again, no remedy for this guy. Furthermore, the defendant's Christian viewpoint that his marriage is not irretrievably broken is never given preference over the plaintiff's view. You remember the marriage vows? Until death do us part? He believes that. She doesn't. Judge, what do you think? Well, I can't think. because the law says I can't think. You understand what this guy's doing here? I think this is incredibly wise.
Oh, yeah.
Yep. When a judge is forced by the statute to exercise no discretion because the statute itself dictates a predetermined outcome in every case, and this is in every case without exception, the judge is not acting as a judicial capacity, but only in an administrative capacity, and this is a violation of separation of powers and due process. I love that. It's a violation of separation of powers and due process. The Pennsylvania no-fault divorce statute prescribes the granting of divorce after a plaintiff has been separated from the defendant for 2 years if she says she feels her marriage is irrevocably broken. In Ryan's appeal, he explained how his wife's lawyer argued that the divorce decree was not a ministerial act because of the statutory requirement of living separate. So in other words, he's saying, well, she's been away from him for 2 years, so okay, judge, take a look at that, and then that's all you need to take a look at. Again, a one-sided unilateral argument. Ryan asserts that the 2-year separation does not invoke judicial exercise of judgment, but is rather a clerical determination. Mr. Anderson, am I explaining this correctly? Because this is incredible. This is incredibly good stuff.
Well, I don't know if you're explaining it correctly or not, but I agree. It's incredible. And it not only for this particular case, but it opens some thinking for a lot of areas.
Yeah. I know where you're going. You pro-life people never stop, do you? Do you? You just never stop. There should be a remedy in law with no-fault divorce, and there is no remedy or allowance for a defense that it is unconstitutional. I'm not a legal scholar, but I think that means innocent until proven guilty. The husband is not responsible for the actions of other people and could not, therefore, contest the actions of others. This too demonstrates that the husband was without defense. The opportunity to defend would require that the husband possess the ability to avoid the contact he is being accused of. Since there is no allegation of wrongdoing in the divorce complaint, then there is no opportunity to defend that which does not exist. Ryan Pankoe. I think I put this on my Facebook page. If I didn't, I'll do after the show. Ryan, Pankoe, Pennsylvania. And I got this, Bay McFarlane. I wrote this article. I read a lot of that on the air today, but I think this is just, when I first read this over, I went, I don't get this. It doesn't make any sense to me. And then I'm going, whoa, wait a minute.
Yeah.
Wait a minute.
It definitely deserves some time.
Yeah. I love it.
I like the beginning question. Well, what's the point of the judge? It's already determined.
And that's beautiful. That's beautiful, because the judge's hands are tied. I mean, they're just passing it. They're charging them court cost, another thing that he could talk about, and then passing it on to the administrators who are going to do the same thing the judge just did. So they're bypassing his opportunity to get a fair trial, boing, and then pushing that over to the administrative staff. This is.
And what's the point of the trial?
Exactly. That's what he's saying. If the Constitution says, what? I have the right to a trial, right? Well, guess what? This isn't a trial. Think about this. I think this is absolutely beautiful. I love it. I love it because of the wisdom that's behind it. Now, I don't know what's going to happen here. We live in an unjust society, methinks. So I don't know. And if our lawyer friend is listening, I'd love to hear what his opinion on this might be.